Yes, welcome to the students of the SLW 670. Karibu sana. Welcome to my class, which is there on scheduled Friday. And read what I posted on the screen. I would like to hear your voice. Unmute and read. Read.
Welcome to the students of SWL 670.
Appraisal of the dispute settlement and institutional framework.
Appraisal of the dispute settlement and institutional framework on intellectual property.
Yes. Hosted by me, that is Professor Dr. Mohammed Saheb in South Manza. So, if you happen to see the 2.6, it is appraisal of the dispute settlement and the institutional framework. And we read patent, trademark dispute, and we highlighted here some of them now in this class. Yes, this is the intellectual property rights regime within the East African community. And the chapter 2 is the Tanzania. And where the introduction goes in this manner. This chapter examines the IP legislative and institutional framework of Tanzania with the goal of identifying the weaknesses and strengths of the frameworks from both the legislative and institutional perspective. It will also incorporate some of the views obtained from the stakeholders in consonance with the international instruments. In making this analysis, it is important to bear in mind that present United Republic of Tanzania came into being in April 1964 as the result of the union between the two countries, namely Tanganyika and Zanzibar. Within the Tanzania constitutional setup, Zanzibar retains a significant degree of the autonomy and such has its own legislative, executive, and judiciary. Zanzibar has a jurisdiction over the list of the matters which are non-union matters. International conventions, unless stated otherwise, during the signing and the ratification, generally bind both the parties, that is parts of the Tanzania, namely mainland of Tanzania and Zanzibar. When the international instruments are concerned, if it is signed by the United Republic of Tanzania, that would be applicable to the mainland of the Tanzania as well as the Zanzibar. But Zanzibar is having own autonomy, own legislature, own executive, and own judiciary, but non-union matters, it will having its own entity. For the union matters, naturally the union government will, that is the government of Tanzania will deal the issues. So the unique history means, yes. Timothy, do you want to say, ask anything?
What?
Will I proceed?
Yes.
Because I heard the sound, that's why I stopped it. Yes, now you mute. This unique history means that the IP regime in the Tanzania is regulated with the two separate and independent legal system, since IP issues are not classified as a forming part of the union matters. As such, for the IP protection, they do mainland Tanzania is different and Zanzibar is different. When institutional and the local framework and dispute resolution is concerned, the two different jurisdictions are there. In this regard, the chapter will first discuss the finding of the IP regime prevailing on the Tanzania mainland, and in the second part, discuss briefly the institutional framework of the in Zanzibar. But will concentrate only the Tanzania mainland. Of course, Zanzibar also there, but more emphasis is there on the Tanzania mainland. At the international level of the Tanzania is a member of the World Intellectual Property Organization, having become a signatory in the WIPO, and the conventions in the December 1983. When the Tanzania said, automatically Zanzibar also became a member, but when it comes to the execution is concerned, it is having its own setup. It is also a party to the number of the IP related treaties and agreements that inform the domestic legal framework. Whatever the international instruments are there, and the Tanzania is going to make domesticated in their legislation also. That is called the domestic legislation or Tanzania legislation mainline. These includes Paris Conventions for the protection of the industrial property, joint June 16, 1963, and Berne Convention for the protection of the literary and artistic work, joined in the 25, 1994. And in your dissertation and your thesis, and you will mention the copyright Berne Convention. Timothy, note the point. Then Patent Cooperation Treaty, PCT, joins September 14, 1999. And the NICE Agreement joined in the 1999. Tanzania is also the contracting party to the agreement to the trade relations aspect of the intellectual property right, means TRIPS. It is also one of the member by the virtue of its being a member of the WTO, which is joined in the 1995. If you once you join the WTO, automatically by virtue of it, and you will become a member, because it is a WTO which made the trade-related aspect of the intellectual property rights, TRIPS. With the TRIPS, we can have a control over the intellectual property in any country in the world. Because in the WTO, World Trade Organization, almost all the countries are the members of in it. Those who are members of the UNO, except a few of them. Regionally, Tanzania is a member of the African Regional Intellectual Property Organization, ARIPO, and we discussed this ARIPO. It is one of the institutional methods of making the things. ARIPO, and is a member of the ARIPO. Tanzania is a party to the 1982 Harare Protocol on Patents and the Industrial Designs in 1993. Even also the Banjul Protocol in the March, both which is a joint September 1999. So Tanzania is a member for the ARIPO. Tanzania also is a member for the Harare Protocol and Banjul Protocol as well as the Industrial Design in 1993. It should be noted in this regard that even though Tanzania is a member of the ARIPO, Zanzibar has not been designated. And Zanzibar IP registration are therefore deemed as a foreign. So mostly the implementation is concerned a little lagging behind the Zanzibar, but generally the laws which is applicable in the Tanzania mainland try to be applicable in the Zanzibar with a slight modification because it is having a separate judiciary and executive and other special status is concerned. So Tanzania IP legislative framework, how you can see it here, the Constitution of the United Republic of Tanzania of 1977, it says provides for the overall protection and the enforcement of the APRs, that is the intellectual property rights. The Union of Tanganyika and Zanzibar Act 1964, which ratified the Article of the Union between the Republic of Tanganyika and the People's Republic of Zanzibar, provide for the government of the United Republic of Zanzibar, make the provision for the modification and amendment of the Constitution and the laws of Tanganyika for the purpose of giving effect to the Union as well as and said articles and for the matter connected with therewith and incidental thereto. Even though Zanzibar also follows certain norms of it, but the highlighted is only the mainland of Tanzania. When a mainland of Tanzania or the Union Republic of Tanzania has signed an agreement that will be applicable to both the countries, that is mainland of Tanzania as well as Zanzibar also. So now Patent Registration Act and how it will be both the places or in the mainland. Let us see it. The Act provides the protection of the invention through the grant of the patents and registration of the utility certificates, and it facilitates the acquisition of the technology for the fair terms through the grant and the regulation of the patents and utility certificates. If patents, a new thing is invented over there, it will be patented. Otherwise, the intellectual property of the person who created it and he will be exploited and he will not get anything. That's the reason he will be protected under the Patents Act. If anybody wants to use it, then he has to apply for the license and pay the money and get the license to utilize the intellectual property and applicable to the intellectual property by paying it to him. The Act establishes the office of the Registrar of the Patent and who is responsible for the administration of the Act and provides for the patent registration procedure. It is also provided for the filing the regional patent and utility model through the RIPO. RIPO is the regional organization. Yes, through it also it can be maintained. And in addition to that, yes, Timothy, I am getting the sound mute. Do you want
Pardon?
to ask anything?
No,
Yes,
no.
mute. Okay, mute. Mute. Still, I did not see. Yes, now you muted. So, according to this act, patent restriction commercial use and distribution of the sale of goods made out of the inventions without the consent of the owner. Yes, it will be punished. It is a breach of the thing. Any person using the exploiting the patented invention without the consent of the owner infringes on these rights, and an action will be taken against them. And who breaches such a thing? Because without the consent of the patent man, the owner, he could not do so. So may face legal action and will be liable for the compensation for the owner of the wrongful acts. Yes, the patent owner has a right to work for the invention without fear of the invention of being infringed or being subject to the unfair competition. So now under the Tanzanian laws, the term of the patent lasts for an initial period of the 10 years. If any patent would be there, it will be last for the extent of the period of 10 years, which can be renewed for the 2 further 5 years terms. 2 further 5 years terms means 10 plus 10, 20, each 5. So subject to the fulfillment of certain conditions are there. Then overall any patent would be there that will not be worth more than 20 years. Is it clear? Overall, any patent would be there would not be worth more than 20 years in Tanzania. The law also bestow upon a patentee the right to decide on whom a license or assigned the terms to be agreed upon by both the parties. It is the owner who has
Pardon.
limited the patent. Yes. Do you want to ask
I
anything?
don't. Yes, I don't understand when you're speaking about Olale.
Pardon?
Olale, when you say that Olale is taking
Owner means the person who invented the patent.
Okay.
Owner means the person who is invented the patent, he is the owner of the patent and he is the master of the patent. Without his consent, nobody should have to use it, provided if he patented in the Aripo as well as in the local mainland of Tanzania.
Okay.
So here says clearly that under the Tanzanian law, the term of the patent lasts for an initial period of 10 years first, and which can be renewed also for 2 further 5 years terms. That means in any case not more than 20 years, subject to the fulfillment of certain conditions again. So the law also bestow upon the patentee, means the person who has made such a thing, the right to decide on whom to license to be given or assigned or terms to be agreed upon by both the parties. Suppose if anybody wants to use the patent, by paying the money to him, take the license, yes, he can make so. But there would be a period would be there, not forever. A license will be given in the period time, 1 month, 10 months. Generally, the license will be given for 6 months, 3 months, or one year, depending upon the agreement of the parties, but not the 20 years. Of course, if the giving of the 20 years, provided the money is more, which licenses money is more. So patents are granted by the government through the business registration and the licensing authority. BRELA is one of the organizations will be there. That is a local regional organization, and it will take up the issues of the patents. BRELA, 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 granted the government through the business registration and the licensing agency. It is one of the body which can create such a thing. So now let us see the trade and service marks are concerned, 1986. It is also intellectual property. This act and is implementing the regulations provide for the registration and the protection of the trade and service marks in Tanzania. Means logos, a trademarks. Like Coca-Cola having the different trademark, even the Vodacom, Airtel, and the another one is even Tigo is having their own logo and trademark, and that should not be copied by any other person. If any resemblance would be there, then I can bring an action against the person who has made such a logo copied, because it comes under the counterfeit logo. So the Act establishes the Office of the Registrar of the Trade and Service Marks, and who is responsible for the administration of the Act. The core idea of the Act is to protect the owners. Who is the owner here? A person who invented the trade, a person who made such a service mark, a person who made such a logo. He is the owner. The core ideal of the Act is to protect the owner of marks from unscrupulous competitors who would desire to take the advantage of the established business reputation of the marks of their competitors. Suppose if a logo is there, a trademark is there, a design is there, which is very much famous by that one, the other people would like to try to copy the same logo and try to sell their own products under the pretext of the counterfeit logo. Like, for instance, we say the Johnson & Johnson, they will produce the Dettol soap. And Johnson & Johnson will also produce all the small babies, the care and medicines and other accessories are concerned. But Dettol soap you will get in the Machinga, which is selling on the road, is very much less. But the same Dettol soap, if you buy from the medical shop, that is a pharmacist, the cost is more. Why? Timothy? Give me the answer. You may ask, what is the question, sir?
Repeat the question, sir.
Johnson & Johnson will produce the Dettol soap. And the soap you purchase from the Machinga, the vendor, a street vendor, that is a less amount. And the Dettol soap you purchase from the pharmacist, the cost is more. Why? Sir, Maching will not pay any license, Maching will not pay the municipal tax, and he will sell for the lesser amount. But the pharmacist, he has to pay all the taxes, hence he will sell for the high amount. Is it your answer?
Yeah, of course, that's the one who his trademark has been registered is paying the tax, but this is the one who will copy, will not pay the tax and actually infringe the right of
The
the one who.
Machingas which are selling the Dettol soap it is not the exact soap, it's a fake soap. It's a copied.
Yeah.
And Johnson & Johnson will not take care of it, because there are many products are there of Johnson & Johnson's are faked, and the people are getting the money. But instead of curbing them, you have to take the more money rather than taking an action against them. So they say, let it be, doesn't matter, because people, those who are having the knowledge, definitely they know they will not purchase from the Machinga, they will purchase from the pharmacist. Because that is a genuine product. So registration of the mark is not a mandatory requirement. Of course, nobody will register it if you don't want. Suppose somebody exploits it, then the problem comes over there. And requirement and provided that in using an unregistered mark, and one does not interfere with the rights of the registered mark owned by the another. So registration of the marks gives an exclusive right of the use to the owner of the mark. If you register it, you can have the exclusive right to use it, and no other person could use it. If you want to use it, you have to take the permission from you and the license from you. Under this Act, a trademark is valid for an initial period of 7 years. The trademark period is 7 years, which can be then renewed for further term of the 10 years. That means, in any case, the trademark will not be more than 17 years. In the first instance, 7 years, and they can be renewed for further term for the 10 years. That means 10 plus 7, 17 years is the trademark life. So application for the registration, the marks are made in writing to the registrar. Of course, there is a registrar for every office should be there. After examination and an application is advertised in the Trade and Service Marks Journal. If the registrar receives the no objection within the 60 days of the advertisement, then he proceeds to issue the certificate of the registration. Suppose if you want to make a registration of a trademark, yes, you can make an application to the registrar. But the registrar will make a notification in the local newspaper. If anybody is having any objection in this regard, because the so-and-so person has come and wants to make the registration of this trademark, 60 days time would be given. If the no objections comes over there, then that trademark will be registered. So the Act provides for the registration of the regional trademarks and the bonjour production of the ARIPO. So here the regional trademarks are concerned. It is made under the bonjour protocol of the ARIPO and international registration marks under the Madrid system of the WPO. So regional is different and international is different. When you want to make the regional, yes, bonjour protocol and ARIPO come into your rescue, but if you want to make it the international registration for the marks, then you have to do the Madrid system of the WPO. And here, there you have to make it registered. So the local registration is different and the international reference is different. So that is about the trademarks are concerned. So now we covered patents, next trademarks. Now let us come to the Copyright and Neighboring Rights Acts of 1999. So this acts provided the protection of the copyright and neighboring rights. It is implemented by the Copyright and Neighboring Acts, rights, production and distribution of the sound and audiovisual recordings, Regulation 2006, and the Copyright and the Neighboring Rights, registration, the member of their works, Regulation of the 2005. See, regulations are different and the act is different. This regulation will make it guidelines how it can be regulated, the main act. So it is consistent with the provision of both the Berne Convention and the TRIPS agreements. Because the international convention would be there for the copyright is the Berne Convention. And it also goes with the TRIPS agreement also, because it also gives certain norms for the trade, patent and copyright and geographical indication, any other IP sector is concerned. So the Act grants exclusive right to the authors of literary. Here they say author because it's a literary work, but he did not say owner here. Because the trade place they say owner. In the patent place they say owner. Is it clear, Timothy? Say yes. So author of the literary and artistic work that are original and possess a creative spark. So the duration of the production of the copyright work is in the case of the natural person, the life of the author plus 50 years. Suppose the life of the author is 60, then the 50 years, 60 plus 50, how much? 110. Over. Later on there is no copyright available to him. In the case of the legal person or pseudonymous works, the duration of the production is 50 years from the date of the publication. Suppose some legal persons are there. Case of legal persons are pseudonym works because they don't want to disclose it. At that instance, anonymous authors are concerned. The duration of production is only 50 years from the date of publication. At that instance is only the 50 years from the date of publication. But with regard to the folklores, means traditional songs, the Act provides that the expression of the folklores are not to be utilized in the absence of the authorization from the competent authority, that is, National Art and Council of Tanzania. If the folklore also be there, yes, it can also be copyrighted, provided the condition they said, provided the folklore authority is there, the National Arts and Council of Tanzania should have to give the endorsement for that regard. Yes, it is said to be the folklore, means the traditional way of dealing the things, or any other songs or any other things are concerned which comes under the custom of a Tanzanians, that is called. So folklore will be there, the National Arts Council of Tanzania should have to approve it. That is the competent authority to say, then only that will be patent, that would be copyrighted. Otherwise, hapana, no. So one of the key feature of the Act that it has established the collective management of the framework in the name of the Copyright Society of Tanzania, that is the COSOTA. It is also a regional agency is there, and it is the institution is there which will take care of it for the purpose of the copyright management on behalf of its members. Under the Act, the COSOTA is mandated to promote the protection of the interest of the authors and other participating actors of the copyright works, then collect and distribute the royalties and other remunerations, maintain register of the works and production and association of the others, among the other things. See, when you are writing, the copyright would be there. Generally, we can make an agreement with the publisher, that is the royalty. In case the royalty is not paid over there, then we can approach the Costa. Yes, the publisher has promised me to pay the royalty and he has sold the books, but he did not pay. Only first year, second year is paid, but third year onwards he did not pay. So he can bring an action against the Costa, and the Costa will take care of it and see that the royalty will be paid to you, because you are the owner of the artistic work. So Costa is mandated to promote and protect the interest of the authors and other participating actors of the copyrightable works, collect and distribute the royalties and other remunerations, maintain the register of the works and production and association of the authors, among the others. So in association of the authors, in the cooperation of the authors, yes, they can do so. So in addition to the traditional acts of the infringement, the Act also expanded the spectrum of the infringing the properties by faulting those who import our own instrument with an susceptible to the use to facilitate the copyright infringement. The person wants to make the copyright because nobody should have to use that material without the consent, without the approval, without the license of the owner of the creator or the person who wrote such a thing, that is called author. Yes, author consent should be taken over there. Suppose the work is published over there, then author plus publisher, both the consent should be taken. But if you are using for the circulation for the student purpose is concerned, yes, you need not to take the permission of anybody, because you are not doing a business, because you are doing a service to the students to give the handouts to them, and at that instance you need not to take the permission of them. But it is only for the private circulation to the students, but not for the commercial use. Is it clear? Timothy, are you there? Say yes.
Yes.
Yes, now you read this thing. 2.225, read.
The Plant Breeder Right Act 2012. Plant breeders' rights in Tanzania are governed by the Plant Breeders' Right Act 2012. This act establishes a plant breeder rights office and set out the legal framework for the protection of plant breeders' rights. However, the plant breeders' right regimes is still at nascent stage.
Do you know what is meant by nascent stage?
At early stage.
What is meant by nascent stage? If you know it, you tell me. If you don't know it, you say pass on. I will give the answer.
Pass on. Pass on.
Nascent stage means infant stage, preliminary stage.
Yes, sir.
Infant stage or preliminary stage. That is called nascent stage. So the Plant Breeders' Rights Act. See, when you make the plants, you can make the different by section. You can breed the plant of the different varieties. So that is called plant breeders. They will make the dissection, they produce the new plant. And earlier, we know the rose is only pink. Am I right? Rose flower is only pink. Am I right? Timothy, what is the color of the rose?
Sir, I didn't understand well.
What is the color of the rose?
Pardon?
What is the color of the rose flower?
I don't know, sir.
You, you did not see the rose flower. I will show you. You did not see the rose flower. Generally, the rose flower color is pink. See, this is the rose. It is a pink color. The color of the rose is generally a pink. See, did you see it?
Yes.
It is actually the original color of the rose. But the plant breeders, they are making such a gimmicks, the crafting, they make it out, and they can produce the even a black color also. A black color rose. Can you imagine? By doing the crafting, hybridizing. Generally, the rose is not black color. Rose is a pink color. But they give the colors because they make the grafting, and the breeders, they will produce the different varieties of the roses. So what I want to say, the plant breeders, I am giving the example of the rose. So plants means anything will come under over there. For instance, you can say cabbage plant, sunflower oil plant, or any plant, they will move the dissection, and the method is that they will hybrid it and they will produce the new product is concerned. So the Plant Breeders' Right Act of 2012 also protect it, but still it is a nascent stage. So 2.26 is other IP related laws. There are number of the other laws dealing with the issues with the touch with the IP, but which are typically not considered core IP issues, and these include Merchandise Marks Act. It is not that much very closely, but still we can use it. And an act controls the use of the marks and trade descriptions. Yes, it is also like a trademark. And the Merchandise Marks Regulation 2018 were put to the place to enable the act deal with the developing challenges in the industry. They provide the description of the marks and enforcement of the APR against the infringers. So each merchandise, they are having a different logo, different mark would be there, and with that they will make the business. If any person makes the copy of that mark or the logo or the design at the time, that he will be put behind the bar, and they will make any damages for that regard, both in the Merchandise Act as well as in the IP Act also. So Business Activity Registration Act, this is also the same thing. Provide the registration of the business names, establishment of the business activities. So registration would be there. The same name of the business should not be run over there. Business registration concentrates on matters related to thereto with the direct impact on the enforcement of the trademarks. So a business which is registered with one name, again the same name, it could not be registered over there. So that is the also comes under it. And a Fair Competition Act, this is another act, the new act is concerned. And the provision encourages the competition in the economy of the prohibiting the restrictive trade practices, regulating the monopolies and concentration of the economic powers and the prices, and the aim of the protecting the consumer. It also provides for the fair competition in trade. In the competition also it should be fair. And no one can sell the michele at the cost of Miatano. Yes. Can anyone sell the michele rice at the cost of 500 Tanzania shillings? Answer is no. Because there is a standard limitation would be there. And up to that extent one should have to sell it under the Fair Competition Act. Yes, After that one, yes, you cannot reduce it because it is a given the last minimum. You have to make it out. Otherwise, the Fair Competition Act, the purpose will be no more in use. It is futile. So the traditional and the alternative medicine act also there. The TK alternative medicine, the Maganga, they will make it out. The act provides for the promotion and the control of the regulation of the traditional and alternative medicines practices. It also establishes the traditional and alternative health practice of the council. It observes. Its objective is to protect and provide for the management of the herbal medicine in the country. The herbal medicine would be there, which is made of the roots and barks and leaves and the fruits of the shrubs and herbs. The medicine would be there and they would like to promote it, and hence it should be protected over there. If anybody make the infringement of such a thing would be there, and he will be put behind the bar, because one can bring an action against the person who made such a imitation and produced the such a medicine is concerned, because under the traditional and alternative medicine act, it is already registered over there. So these are the things where we can come across in the 2.2 is concerned. Then the 2.2 is 2.3 is the institutional framework. In the IP in Tanzania administered the number of the different entities. The following subsections discuss the principal bodies involved in the administration and enforcement of the IP rights. And we will see in the tomorrow class, the next class, the institutional framework. So where it is said no institution, BRELA is there. I already told you it plays an important role. Then the Society for the Tanzania, COSOTA is there. Yes, it also plays an important role, because these are all the institutional things which wants to protect the persons, the invention of a particular person. Then the register of the plant breeders' rights also there. This is another, like the just we have studied. And 2.3.4 is the other institutions, like the Fair Competition Commission is there, FCC, that also protects the product and the merchandise. They should not supposed to sell any product less than a particular a minimum rate which is prescribed over there. And the Tanzania Bureau of Standard is there, TBS also. It also helps, because any product, if anything will be prepared over there, you should have its own standards. That is called the standards. Tanzania Bureau of Standard, TBS also there, one of the organization. Then the Tanzania Food and Drugs Authority, TFDA also come to the picture to see that if any product is manufactured over there, and it should be consumable in nature and work to consume it, and doesn't have any side effects for that regard. And the Tanzania Commission for the Science and Technology and COSTAC also play an important role to see that how technology will be controlled over there. And Small Industrial Development Organization, SIDO, also comes into the picture, and it will also observe it, how the challenges of the SIDO related to the inadequate funding and training and technical manpower, and how it can be there. It is awareness of the role, especially with the music industry, or unwillingness to cooperate in the interagency levels, and low number of the innovations from the universities and research institutions. Then the Confederation of the Tanzania Industry, CTA, also plays an important role for the independent, self-financed, legally continued business membership organizations. And then we can also see the Tanzania Chamber of the Commerce and Industry Agriculture, that the TCCA also is one of the institutions will regulate it and see that how it can be maintained. So under the 2.3, these are the organizations which can maintain and see that it will be made. So 2.4 goes the enforcement of the IP and anti-counterfeit activities. But the time is not sufficient over there. But now the time is 9:49, 9:50. I believe that at any time, of course, the indication is still, I did not get it, a 5 minutes indication. Otherwise, it will be closed, because I started by the 9:10, but still we do have, because it's the 40 to 50 minutes should be there. And sometimes the Cisco WebEx is kind enough to extend the time also, because they will forget it. So now what I want to say is how Tanzania, especially the mainland of Tanzania, will try to make the protection of these patents, copyrights, trademarks, how the institutional methods are there. And the institution, just before I narrated, there are several institutions would be there who would take care of and regulate the intellectual properties.
Mungu ibariki Afrika, wabariki viongozi wake, hekima, umoja na amani. Hizi ni ngao zetu Afrika na watu wake. Ibariki Afrika, ibariki Afrika, tubariki watoto wa Afrika. Mungu ibariki Tanzania, dumisha uhuru na umoja wake kwa waume na watoto. Mungu ibariki Tanzania na watu wake. Ibariki Tanzania, ibariki Tanzania, tubariki watoto wa Tanzania.
Sikiliza mimi darasa, asante sana, nashukuru sana. Mungu akubariki na kukulinda.